Welcome to the program. My name is Marty Shenkman, and I'm joined by a number of very bright colleagues, Abigail O'Connor, Jonathan Blotmacher, and Todd Flubacher. And we're going to talk about the new Delaware Well-Being Trust statute, and hopefully in a much more important and broader way, just about the ideas behind the statute and how we can infuse really important human ideas into the drafting and trust administration that we all do. Before we get started, just very quickly, the PowerPoint is going to be posted on the web console. It'll be posted to the PEAK and ILS websites, eventually to mine as well, along with the materials. So if you miss anything, you can get it. We don't give CLE or CPE, but you will be sent a certificate if you self-report. And Teresa, tell everyone about ILS.
Absolutely. Thank you, Marty. Interactive Legal is pleased to sponsor today's presentation. My name is Teresa Bush. I'm the Director of Education for Interactive Legal, and we are, of course, a provider of automated document assembly programs that we used to call software, but now everything is web-based. Our wealth transfer planning system is designed for high net worth estate tax planning and also ordinary net worth estate planning. There are a lot of attorneys behind our language, a team of experienced attorneys. And I myself, for example, practiced for 16 years before joining Interactive Legal 17 years ago. And our other attorneys at Interactive Legal have that same level of experience. So we're really proud of our language. Quite a bit of it came from one of our panelists today, Jonathan Blotmacher, and some of it will be shared in today's presentation. So if you would like more information, you can always go to interactivelegal.com, read recent blogs, watch recent webinars, schedule a live demo, and I will turn everything back over to you, Marty, because I'm looking forward to today's presentation.
Just to add, there's a lot of very interesting ways to personalize estate planning documents in Interactive Legal's system. Beyond just the language we're showing you today. This is barely an appetizer. And that to me is part of the power of using document generation, that it becomes so easy to tailor documents without having somebody sit and draft something which could introduce errors and somebody review it. You click a button. And I think as we move more and more towards customization and dealing with human elements of planning like we're going to talk about today, the power of document generation software is really significant. Our second sponsor is PEAK Trust, and Abby is getting paid double today because not only is she a panelist speaking, but she's going to give you a little background on PEAK.
Thank you, Marty. So I'm Abigail O'Connor. I'm the Chief Fiduciary Officer of PEAK Trust Company, also an estate planning attorney. But PEAK Trust Company is a corporate trustee in Alaska and Nevada. We do a lot of directed trusts and bifurcated trusts. We also can serve as the sole trustee, but PEAK built its premise on the original Alaska Trust Statute, which was introduced by Jonathan, who's here with us today. And we love working with attorneys, and we welcome sophisticated planning and complex issues, and it's one of the ways that PEAK shines. So thank you, Marty.
The biggest asset that PEAK has. Who's their general counsel now, Abby? Trust counsel.
General counsel.
Trust
no,
counsel.
I'm not. I'm not trust counsel. Chief Fiduciary Officer, but.
Oh, Chief Fiduciary Officer.
I appreciate it.
So the biggest asset for PEAK, sorry, Jonathan, is you get to talk to Abby.
Amen.
Although sometimes she makes you feel bad by showing you pictures of all the big fish she caught. So Todd, you want to just introduce yourself real quick and then we'll jump right in.
Sure, absolutely. My name is Todd Flubacher. I practice at Morris Nichols, Arston Tunnel. I practice almost exclusively in the area of a national practice where we work with law firms and clients around the country and around the world that use Delaware as the situs for their trusts, using all of our tools and techniques and special statutes that we have in Delaware to provide the Delaware Trust Advantage. And I'm really pleased to have the opportunity to do this. Marty, I've seen and have gotten emails and information about your webinars for many years. Abigail and I have had some opportunities to cross paths and work together a lot more lately, which has been really great. And Jonathan, you've done work with our firm and my former partner for 26 years that I've been practicing. And for 26 years, I have held out the secret hope that a Blattmacher-Flubacher pairing would someday happen, because I think it would sound cool to have the, and Marty, if you want to change your name to Shenkman or something like that, we would really, and Abigail, you know, O'Connor and Bacher, I don't know. So anyway, that's all I wanted to say, but this is a highlight for me to have Flubacher.
What does Flubacher mean, Todd? Blattmacher means paper maker, and that's why I became a lawyer.
So my aunt does all that kind of genealogical stuff, and it translates apparently to like the flue is a stream that's coming out of like a mountain into it, like down a waterfall. And Bacher, I think, has something to do with the town or something. So it's some little settlement that's next to a waterfall in a mountain somewhere in Austria or Germany or something like that.
Let me just make a quick introductory comment, and I may be wrong, but just a thought, and Todd's going to then talk about the background to the statute and why it's there and why they did this and everything else, which will tee up the whole conversation. There may be others, but I know Tom Rogerson for many years, and he had promoted the concept of creating a family advancement sustainability trust for decades, and others may have done stuff like that as well. And oops, sorry about that. What he did in his presentations, he facilitates family meetings, helps develop family culture, family mission statements, and had proposed a long time ago that to make this happen, it's not just enough to do it under a general trust with discretionary provisions, even if it's permissible, but if you make it explicit, people see and understand that this is a priority, this is something that the family's putting importance on. And he used his acronym FAST Trust. I don't know if it's fair to say, Todd, but you can feel free to comment, but I just wanted to give him credit. And I don't know if he had any involvement in the Delaware statute, but people have talked about these concepts for a long time. And I think it's really important. So Todd, I'm going to turn it over to you and just holler when I should advance the slide if I don't do it at the right cadence.
Sure. Yeah, I saw Tom Rogerson give a speech probably 20 years ago or so, and he's worked with a couple of different corporate fiduciaries. He's an excellent speaker, but you know, the topic really hit me in terms of the people side of all of this planning, and not just asset protection and tax planning and growing wealth and things like that, but what are the lived experiences of the beneficiaries and the descendants, and what is the real why when we are doing all of this sophisticated trust planning that involves really large trusts. And so in those last 20 years, I've just seen a growing body of books and articles, discussions at conferences, and just, you know, a much higher profile of this topic in the planning community. It's expanded, and I got affiliated with things like the Purposeful Planning Institute and Ultra High Net Worth Institute and others that really, you know, family office groups that the next gen and how, and it's beneficial to the fiduciaries, it's beneficial to the families, and it values the real purpose of leaving a legacy and having a positive impact on the descendants of the settlor. And at the same time, what I've noticed is really a compression in our fiduciary industry of the concept of what the fiduciary does, and in no small part to the things we've done in Delaware and in Alaska and some of the sophisticated planning with directed trusts and trust protectors and bifurcating responsibilities and worries about fiduciary risk. So the role of, it's rare that you see a fiduciary that's a full service trustee that gets paid enough to have the capacity and time and bandwidth to pay attention to the beneficiaries and to engage with them, to sort of have that beneficiary perspective and their well-being as a part of trust administration. And the exemptions are getting so large, and the techniques are getting so good with, you know, installment sales and discounting and all the sophisticated transactions, that there are so many trusts with really large amounts of wealth that settlors have an increased fear of the impact, the negative impact that inherited wealth can have on the descendants, and whether it's going to ruin their lives and make them lazy or unproductive or attract the wrong kind of people, or, you know, fall into, you know, some sort of substance abuse or things like that. And that fear that has been expressed time and time again, as I'm seeing, you know, all the confluence of all of these things, the reduced sort of role of the fiduciary in administering the trust, and this growing fear, then people started to turn to silent trusts. We have a silent trust statute in Delaware, and there's silent trusts everywhere. And, you know, by their nature, the fiduciaries are prohibited from providing any information to the beneficiaries, even though technically they're currently beneficiaries and could get distributions until a certain age. You know, in Delaware, we have it where it can be a silent trust for a period of time. So at some point, there's this big reveal. They're going to learn about it at a point in time when, you know, a lot of their life decisions might have been different had they known that they might have had a cushion, or, you know, even the ability to ask for trust distributions. And then there are the practical aspects of administering silent trusts. And, you know, if you do make a distribution, you know, how do you hide the fact that there's a K-1 that goes out and it gets attached to their tax return, things like that. And so there are all of these, you know, compounding problems around this issue. There's a lot of let's switch to the next slide and we'll go to, so the traditional planning approaches, when we're counseling clients, what we know best is minimizing estate taxes and leveraging, you know, the techniques that we have to put the maximum amount out of the estate tax system in trust. And the techniques that we use, and a lot of times without explaining all the ramifications or having dialogue with the settlor, is either restricting distributions or restricting information. And I've touched on that with the silent trusts. I've seen trusts where, you know, with the control of the dead hand, you know, there are all these mechanisms and triggers of ages or turning off distributions of certain, you know, negative, sort of negative conduct or different, you know, things like going to college and whatnot are not met. And if I had a dime for every time I've seen one of those things go wrong, where, you know, they're unduly restrictive, you know, I'd have enough to have my own trust, because you know, these things just are problematic and have failed to achieve the goals. Another approach on planning is to really hardwire the well-being concept to distributions, and have the trustee responsible for making distributions to ensure that beneficiaries are happy and, you know, have positive psychology, and that you're making distributions for encouraging things. And that's kind of unworkable because it requires a lot of discretion, and it requires a lot of time that the fiduciary is not getting paid for. And so you just see those things sort of, you know, fall in their face, and they haven't been as effective in this space as it could have been. So what we've done with the Delaware statute is create a somewhat, you know, different approach, and we're going to touch on how and why that's really a completely different approach than what I was talking about to try and address these things. Yeah, the two slides that you had up there, Marty, you know, there are a lot of provisions in trusts that are in our boilerplate, and I talk about this a lot too. You know, whether you have a distribution standard that is HEMS or sole discretion, or you have no contest clauses, or you allow one beneficiary or, you know, one child or all of the children to have removal and appointment of fiduciaries, or you give them powers of appointment or you don't. There are a lot of real implications to how the beneficiaries are going to experience the trust, whether the trustee is going to ask them to provide their budgets and tax returns in order to get a distribution, whether it pits one child against the other, whether they feel that they have autonomy with, through the exercise of a limited power of appointment or something like that. Restraints on requiring them to have prenuptial agreements and things like that. It can really have unintended consequences of hurt feelings and distrust of the fiduciary, and it can create conflict between the beneficiaries and the fiduciary, where it could lead to litigation in some situations, and really have the opposite effect of what the grantor is intending, right? The grantor is trying to create a trust to improve the lives and extend the legacy and really kind of leave a little bit of goodwill to the descendants, and instead it ends up backfiring and there's resentment. So let's talk a little bit about this approach that we've taken in Delaware for beneficiary well-being. Instead of, it occurred to me as I was working with some folks in this area, giving some presentations on this topic, that where the shortfalls are with tying well-being to distributions and the trustee's distribution power to, with sort of precatory language and standards related to well-being for whether you're making distributions. What if we just gave the trustee this explicit trust power and authority to provide what we're calling beneficiary well-being programs that are more targeted in terms of addressing the beneficiary's ability and capacity to handle inherited wealth and have dialogue with the advisors and with the trustee and understand trust account statements, the tax issues, their own planning needs, wealth management, budgeting, and essentially use the trust as a family bank to pay for the expense of those programs, and then basically have that as an add-on to what is otherwise a normal trust, right? It's a trust that has discretionary distribution standard in most cases, perhaps for health, education, maintenance, and support, but also, and I've used the metaphor of the bundle of sticks to describe this. In property law class in law school, they talk about how you have all these different property rights. You've got, easements you can sell off and all these different things, and that all these different rights and interests that you have in property are like a bundle of sticks. And I was thinking of the beneficiary's rights and interests as a beneficiary of the trust, to be able to get information and account statements, to request distributions, and so forth. What if this is a trust where we add another bundle, another stick to the bundle that basically provides the trustee shall provide the beneficiaries, and the beneficiaries will have the right and the interest to receive beneficiary well-being programs at different stages of life, where they where the trustee would have meetings and provide coaching and seminars and programs and things like that to prepare them at different life stages where the trust fund itself could negatively impact the beneficiary's well-being and their capacity to sort of handle inherited wealth. Do you guys want to chime in at this point on anything that I've said, because I've talked for a little while?
Well, Todd, this is Jonathan. I guess there's always a question about what is the best thing to do. I mean, every successful person that I've known, other than their family, will say that the best thing they ever accomplished was to build their own business or own company or whatever it is. And, there's an argument that, Teddy Roosevelt felt that there should be almost a 100% estate tax, because he felt that the young men that he grew up with just had lost the incentive to produce for themselves. And I rarely have it, but I've had a few clients who have limited what their children or grandchildren could receive because they didn't want to take away their incentive. I suppose that part of the well-being trust is to think about how is the beneficiary going to react to all of this wealth and all the things it could do, whether it's charitable, whether it's entrepreneurial or whatever. And I think that that's something, we could debate for days and never come up with a clear consensus of it. But, there's an awful lot of wealth that's being transferred. Of course, one of the things to think about is people get very angry that you have an estate tax in some jurisdictions of 50% or possibly more. But if you have just one sibling he or she is going to take as much as the government would take. And if you have more than one sibling, all of a sudden your wealth is being really eroded. And so when I've had people tell me that they are angry that the government intends to tax their parents' wealth when they die, I point out that if you are really concerned about getting the maximum, you ought to recommend strict birth control to your ancestors. So, you don't have to share it with many people. But, that's not the way life works. And Todd, I'm sure you've experienced it where an awful lot of wealth is turned out to be really negative for people. I don't think that, we can change that from happening from time to time. Although Todd, as you point out, you could design your trust any way you want. And I've had certain people, of course, put in provisions that unless the beneficiary lives a lifestyle which is compatible with what the person who created or who holds the wealth thinks is proper, that they are limited in their distributions or cut off entirely.
I think that that's the stick, right? If you don't do what I want, bam, you're getting less. And that's also very hard because what if a particular child has a learning disability, a health issue, how many different variations, variables, what ifs can you possibly account for? But it seems to me what Delaware is doing, and whether we draft it or not, we're going to talk about, but what Delaware is doing is kind of what I mentioned from Tom Rogerson in the beginning is, hey, if we can take a deliberate perspective, if we can really talk to beneficiaries, not just give them dole out money when they're good or even just dole out money regularly, but rather try to help advance them, try to help educate them, give them an understanding of what the trust does and doesn't do, what the benefits could be of the wealth that they're coming into, whether it's big or small. Even small amounts of wealth can be life-changing if they're handled properly, right? It could be the down payment on a home. It could be that nest egg to grow for your retirement so you have a little less pressure. But so many beneficiaries don't have the knowledge or training to really understand that. Abby, maybe you can comment because you've seen a lot of trust beneficiaries. How many of them really seem to understand, and where do they get their knowledge or information or training to understand what this all means?
Very few of them have a deep understanding as to what it all means, unless they have been trained usually by the family and a proactive family that wants engagement with the next generation. And that, to me, Todd, is what you're talking about with the statute, is really turning a negative into a positive, where right now we write a lot of trusts where we say, okay, no distributions unless you have a prenup and unless you are engaged in a profession or doing this or that or the other thing. And instead of nothing unless, it's no, here's what we want you to do. And it's empowering instead of restrictive.
It's a carrot, not the stick.
Yeah, it is the carrot and not the stick. And the beneficiaries who seem to benefit most out of the trusts are those who are fully engaged and understand and value what it's doing for them long term. And I hear, Todd, that's what you're talking about doing, is make it more of a value to the beneficiaries.
Yeah, I think I like the word training because, it's like in some respects, these people are born into a family where they're a beneficiary of a trust. And there's a lot of complicated things that come along with that. You're going to be sitting in rooms with bankers and trust officers and lawyers and accountants and all that stuff. And there's training that has to kind of come along with that. The clients, when their children turn age 16, they don't just hand them the keys to the car and let them take off out of the driveway. They take them to driving school and teach them how to drive the car before they give them.
Perfect analogy. That's a great analogy.
And
we don't do that in our field.
One of my frequent co-presenter, she practices in this area and she's written books. Kristen Keffler, once when we were talking, she gave us, and she says this in her books, that she herself came from a family where she was a beneficiary of a trust. And she said she would sit in a room with people talking about the GST tax, the estate tax, distributable net income, estate inclusion, appointing executors, you know, when your parents die, persterpes, this and that. You look at trust account statements and there's a principal ledger and an income ledger, and some things go to income and some things go to principal, and, you know, how to decode where the fees are being paid from and things like that. It all is going over her head, and I'm sure it's all going over most beneficiaries' heads if they aren't practicing, you know, trust and estates lawyers or you know, wealth management professionals. And I mean, when we hire first-year associates at our firm, it takes a while for them to understand, you know, the concepts of trust merger and decanting and GST tax implications, general versus limited powers of appointment. And yet we are creating trusts that are becoming 50, 100, $500 million, and the descendants are in a position where, you know, they need to think about why are those prenup provisions in the documents. It's because you're afraid your child or grandchild is going to be stupid, get married, take the money out, put it in a joint account, and the spouse is going to whatever, right? So if they understood and got the training to understand more about asset protection and what that means and why they need a will and, you know, all these different things, or maybe why they would come to their own conclusion they need a prenup, perhaps, you know. So that's kind of the concept, is to use the trust. It's like, boy, there's a big pot of money that could ruin the lives of my descendants. Oh, if only there was a big pot of money that could be used as a family bank to pay in perpetuity to ensure that all of my descendants, you know, who are ever beneficiaries of this trust, are given the opportunity to learn and understand what it is that they are going to need to know to successfully navigate this landscape. On the next slide, you know, over the last couple of months, I've been reading and looking at these studies that have been going on for, you know, well over a decade, and I'm sure there are many more studies than this. But they really, based on sort of empirical data, they link financial literacy is directly linked with financial capability, and financial capability is directly linked with improved, you know, psychological well-being. It's and you can see in that second study that was done in 2022, it's an independent social determinant of health and psychological well-being. The 2011 study focused more on stress-related illnesses and substance abuse and other psychological impacts, and the way that they are influenced by having financial capability. So when you have the ability to budget and to not spend more than you take in, and to understand planning and preparing for the future and what would happen if you lost your job and things like that. And this is obvious, right? I mean, this makes perfect sense, that if you can ensure that beneficiaries have financial literacy and therefore financial capability, that they are going to be better prepared and have better psychological well-being as beneficiaries of the trust when the stressors of, you know, a parent dies, or they're able to come into, you know, withdraw or get distributions of substantial amounts of wealth, and how do they, you know, invest that? What's the landscape of the kinds of professionals that they might use to help them manage the investments? What does that mean for their estate plan and so forth? So there are empirical based studies that link that, and what we did with the Delaware statute was really take this more narrow specific path of targeting financial literacy and financial capability, and also the family legacy, family values, and family dynamics, and make sure that beneficiaries are offered, you know, the professional advice and counseling that they might need to be able to give them the knowledge to you know, navigate the landscape as a beneficiary.
Todd, what were the reasons the statute was introduced? Was it that, gee, you know, there's not enough attention and focus on this, and if we have a statute permitting it, maybe people think about it more? Or is it more like trustees were concerned that, gee, we'd like to do these things, but can we do them? Can we get paid for them? What was the reasoning behind, or the objective behind the statute? Because I think that'll be helpful to understand.
Yeah, I mean, it's I'm on the drafting committee for the Delaware legislation, and it should never be the case that any one person says, "Oh, you know, here I had the idea for this, or I was pushing this, or whatever." It's a committee-wide effort, but I do think it's fair to say that, you know, I had a real appetite for learning more in this space and focusing on this because of the dynamics that I was talking about at the beginning of our discussion, and there weren't any statutes anywhere that do this kind of thing, and it's sort of just sort of underscoring the concept and elevating the awareness, and hopefully introducing tools like this to the discussion that planners are having with their clients about the options. And this, combined with our letter of wishes statute, which we passed the same year, it all embraces effectuating settler intent and sort of having sort of more positive type legislation around that, as opposed to, you know, legislation that many, you know, often perceive as, you know, sort of protecting trustees, or, you know, pushing the envelope of flexibility to modify irrevocable trusts and things like that. So this is another tool in the toolbox, and is also sort of counter programming as an alternative to silent trusts, and to address this rising concern about the negative impacts that inherited wealth can have on descendants.
Todd, am I correct that even though Delaware has a statute, in almost any jurisdiction, you could add these provisions to the trust? In other words, you wouldn't have to make reference to a statute in order to get these powers. You could put it into the trust itself.
Yeah, I think you could draft, and, you know, well, I guess we're going to get into the meat of the statute right next. But I think, you know, what we've provided in the Delaware statute could be drafted as a part of a trust agreement. And I also think that a lot of corporate fiduciaries were doing this anyway for their large, most valued clients, where they're getting their, you know, largest fiduciary fees, and they have these next gen groups, and they have people focused on, you know, going out, meeting with the client, talking about the kinds of things that are in this statute, and the expense of that is just covered by the trustee fee that they charge for serving as trustee. And if there's any impediment to trustees just doing this all the time, or, you know, a lot more than they are, it's the fact that there is a cost to providing this. And again, with the compression of the fiduciary business and the role of the trustee fees, there's a lot of fee compression, and you know, you don't have the time and the capacity to provide this thing to any, you know, for any trust. And also, most attempts at this involve a lot of discretion, a lot of, you know, hand-holding by the trustee, and a lot of this stuff is really tied to distributions. This statute's not tied to distributions. This statute is tied to, in the administration of the trust, the trustee shall provide these beneficiary well-being programs by meeting with the client, or having a professional next-gen, you know, counselor, or, you know, financial advisor or something like that, coach up the beneficiaries on these topics. And so it's a different approach. But yeah, these are the types of things people could draft into the documents. Although, to my knowledge, I don't think anybody was taking this type of an approach to well-being before. I think it was more related to, you know, the trustee through the distribution lens, you know, sort of, you know, tying it to distributions to beneficiaries.
I think one of the reasons that practitioners are hesitant to spend a lot of time on this is when we're billing for our time, clients often are reluctant to go off on what they may view as tangents that we may view as good planning. And clients don't want to spend a lot of time discussing even ancillary planning issues, because they feel a clock is ticking and they want to get the documents done. And in fairness to the attorneys, if a client's first question to you is, how much do you charge for a trust, or whatever kind of trust they're looking for, it doesn't exactly give the attorney the flexibility and the confidence that I can go sit down with this client and really talk to them about issues that I see pertinent to them. I mean, when you look at the statistical data, and we have some of it coming up, we'll go through it just very, very briefly on addiction issues and mental health issues and so on and so forth. I mean, these things are not rare, and yet we don't get enough time spent with them. But I think a comment you made earlier, you know, if we're going to have a $15 million permanent exemption, it's a tiny percentage of the population base that's going to be subject to an estate tax. And these other things may become more important. And I also think as AI becomes more and more pronounced in the profession, these sort of qualitative, not quantitative areas of planning and discussion become even more important, because those are things that cannot be automated away from, you know, the human being, the professional that's involved in the process. Any thoughts, anyone, before we go on?
Yeah, no, this is where lawyer as counselor, the ones like us that have got a few gray hairs or been around for a while, Abigail excluded. Just looking at the screen here, it doesn't look like you fall into my camp on that. But you know, talking to that's right, the tension between what you charge clients because there's an hourly rate and their willingness to pay for that, the pressure to sort of get through the process efficiently, sort of as a pressure to not sit down and really go through all of these concepts and provisions and things like that. But when you've been around and you've seen trust litigation and you've seen, you know, issues within a family related to this stuff, you have experience to draw on to be able to counsel the client and say, well, if you do it, you know, this, you could, you know, I've seen this happen, and you know, that's the value added, I think, to having, you know, some longevity in the career and some experience. And when AI is doing sort of more of the routine parts of the planning, and you have that go on, the ability to sit across the table and describe and discuss these intangibles and these personal issues and to draw on experience is really where I think there'll be more value added. And that's the lawyering, right? Is being a counselor and not just putting a document in front of the client saying, I think this is, you know, this is the best thing that, you know, best form of a trust agreement you should have, just signed here, but sharing your experience with them. And that's where you can get into some of these things about, well, how will this impact the family? How about this? Or what do you want for this? And, you know, and ultimately perhaps getting to a point where some version of some of these issues might actually, it doesn't have to be all or nothing with the well-being concept.
All good points. And I hope that all the colleagues, our colleagues in all the allied professions, if they would all broach these topics as important with the clients, when we sit down to talk about them, it won't be the first time the client has had a heads up that, you know, you need to talk about what this wealth you're passing on is going to actually do to the kids. And I think if they hear it from their accountant and their wealth advisor and their attorney and their trust officer, they're going to start to get more inclined to really address stuff than if they only hear it from one of the allied professions. I'm going to take a few minutes, and I'm not going to belabor it, but I think it was just helpful. I think it was Abby's idea, but then she gave it to me, to just walk quickly through the statute. And if any of you guys want to interrupt me, please do. The statute's not that long, and I'm just going to kind of summarize, paraphrase a few of the provisions, because it's not that long, and give you a few comments on it, and then we'll have a more in-depth discussion following that. But with the background that Todd has now given us, we now understand where this came from and what it was trying to do. And I think whether you're in Delaware with a particular trust, not in Delaware, addressing these concepts is really important for clients and something we all should be doing more of in more client situations. So the statutes, it's 3345. I think it's A through D, and we'll go through it fairly quickly. It applies to any trust, the governing instrument, which makes express reference to the section. But again, as I think Jonathan pointed out, you don't have to be in Delaware. You don't have to opt into the statute. You can draft some of these concepts right into your trust agreement. And as we pointed out when Teresa was talking about ILS, a lot of the document generation software programs have a lot of options about things, whether it be, I think Abby mentioned, you can't get a distribution if you don't have a prenup. There's lots of personal or well-being type provisions in a lot of the software that's out there now that we can all use. If you opt in, you're going to be known as a beneficiary well-being trust, and the provisions of the statute will be available. You can provide beneficiary well-being programs, which means seminar courses, programs, workshops, counselors, programs, family meetings, family retreats, family reunions, and so on, for the various purposes we're going to come to. I think many, if not all of these things, could be paid out of a trust that gave a trustee a discretionary distribution standard. But I think the idea of the statute making these things clear and listing a whole bunch of ideas is something that will help practitioners, trust officers, clients all focus on it. It's also important that a lot of old style trusts, and even trusts that are drafted now because you may have a beneficiary as a trustee and beneficiary, are limited to HEMS. And some of these programs or beneficiary well-being expenditures may be beyond HEMS. And that's an issue Jonathan's going to talk about when we come to some of the tax and asset protection implications of this. I'm not sure that just listing this or spending money without more is going to really do enough. So the fact that, a family vacation is paid for out of a trust doesn't make that family vacation become a family reunion or a family retreat. It's got to be deliberate. It's got to be planned. And as I said somewhere in one of the slides, you may want to hire a professional who facilitates these kind of family interactions with an agenda and a program designed to meet family needs. Some of the goals and things in the statute: preparing each generation of beneficiaries for inheriting wealth. And as we talked about a few minutes ago, a lot of, especially younger beneficiaries, they're not trained, they're not educated, they're not informed to really understand a lot of the implications of this. It seems to also contemplate helping the beneficiaries with their own estate and asset protection planning, developing wealth management and money skills, financial literacy, training beneficiaries to better understand their own finances will, according to the data Todd gave, make them happier. And that makes perfect sense. But they'll also better understand the role the trustee plays. I'm sure that we all have seen a lot of beneficiaries that view trustees as just those people that say no, and that's not what they're doing. And if there's a deeper understanding, it'll probably make it easier and less adversarial for the beneficiaries that are not getting what they want to understand perhaps why. Business fundamentals, entrepreneurship, knowledge of family businesses. It's a great idea to help make the beneficiaries self-sufficient, to help them with, encouraging education to do that, and philanthropy, a lot of which could be done at a family level. Educating beneficiaries about the family history, family values, family governance, all interesting stuff, and stuff that can be fostered if no one else is doing it, perhaps by a trustee, and pay for it out of a family trust. Family mental health and well-being and connection among family members. We're going to talk briefly. I'm going to just give you a few statistics in some of the later slides about mental health, addiction, and other issues. But fostering mental health does take a deliberate intent and focus on it. And too often, a lot of these issues, especially if the beneficiaries are on the surface coping, are not really being addressed. The trustees and advisors shall provide the beneficiaries individually as a group with beneficiary well-being programs, et cetera, et cetera. One of the issues, and we may come to this later, is what about the disparity between what is given or benefited one family line versus another? One of the classic examples is child A has no kids, child B has 6 kids. Are you paying for 6 hotel rooms and 6 airplane flights to the family reunion? So some of those things may be important to address in terms of perception of beneficiaries and trustees' responsibilities. Fiduciary duties and authority of the trustees under subsection D. You have to consider, obviously, the state law and the governing instrument, and they can pay, subject to those, the costs of these beneficiary well-being programs from the trust. And that's very powerful, because if the trustee felt that these certain programs were not within their purview, perhaps they wouldn't pay for them. And even if the trustee feels it's within a broad discretionary purview, having the statute give them authority to do that may make trustees, and Abby, maybe you'll comment on this in the next section, feel more comfortable from an exposure standpoint paying for something because now it's sanctioned in the trust agreement or in the statute. The trustee itself may provide beneficiary well-being programs and can select, hire, retain, and pay providers and so on. One of the things that concerns me is certainly some trust companies, once they achieve a certain size, can afford to hire and have on staff expertise to do some of these things. But, you know, if an attorney is serving as a trustee, especially in a small firm, do they have the wherewithal to really have some of this expertise in-house? A larger law firm may in fact be able to hire people to do this, but not everyone can.
Let me interrupt here, Marty, by saying that there was a lawyer out of Baton Rouge, Louisiana, named Jerry Levan. And Jerry was approached by a family which said, you know, we've had a patriarch who's made all this money and he won't do any estate planning. So Jerry was hired by the family to get him to do it. Todd, I don't know whether you ever dealt with Jerry, but he was a very, very interesting guy. And he took this on for this family and the client rejected him. And the lawyer finally hired a psychiatrist to meet with the client. And after many, many months, the client finally agreed he would meet, and he finally agreed that he really should do something about managing his wealth and doing estate planning. And Jerry built his whole practice on that. I think there have been a few who've done it, but this kind of is consistent with that, where you really want the best interest for the family, and people will disagree as to what that should be. But it was very interesting what Jerry built, and it wasn't even half about taxes. It was about doing the right thing for the family and preserving what the patriarch had really built.
Thanks, Jonathan. Abby, do you want to do this next section with me, and I'll jump in on the slides that I added?
Thank you, Marty. Yes, absolutely. So one of the interesting parts I thought about this statute, and with my trustee hat on, I'm always paying attention to may and shall. And this statute specifically says that the trustees shall provide the beneficiary. So this is an opt-in, and it really is mandatory. I mean, and as a trustee, that helps because our number one goal is to effectuate the grantor's intent, and saying shall is a good indicator that this is what the grantor wants us to do, is to go ahead and pay for these programs. And it also provides a response to a beneficiary who may object to one of the programs. So that's helpful to have that requirement. You know, it's interesting to me how this will change the relationship between a trustee and a beneficiary, because right now, and we were saying earlier, that many beneficiaries don't understand the technical parts of trust. They don't understand the tax. They don't even really understand why the trust was created. All they understand is their role, which is to ask for distributions. And that's what they understand. That's what they know. That's what they can relate to. But this is going to change that relationship in the discussion. Instead, is to be, okay, how can I learn, and how can the trustee help me learn? So that I think long term will be very positive for the beneficiaries and for the trustees, because if it can turn into, I don't want to use the word partnership because the beneficiary doesn't control, but if it can turn into more of a working relationship between a trustee and a beneficiary, I think long term there's a much higher chance of success, that the trust will actually serve its purpose, and the grantor's intent will end up coming to fruition, which is what we want to do. So, you know, the way I see this statute is it's a wonderful starting point. It's an easy way for a practitioner to just say, yep, this is what we want to do this. But then the trust can go on, and the trust agreement can give more instructions or give more ideas. We'll talk later about a letter of wishes. I think that's also very helpful as to what did the grantor have in mind. And then The statute does give the trustee discretion if you don't have to do more. You can just use the statute, opt in, and kind of like, we'll take it from there. And I think that's helpful as well. So then the next question is, what are we talking about, and what is the program? And the statute does give good guidance as to what kinds of things, as the trustee, I start asking questions, and I know we'll get into this later, but it's probably appropriate here, as to, okay, there are probably some easy buttons. There are, the beneficiaries want to take courses at a state school or university. I mean, that falls under education, but that could be something that's pretty easy. But there are vendors available. I was thinking earlier, that second purpose of learning the family values. I was at Heckerling this year, and there's a vendor who, what they sell is basically capturing the family values and the family statement, the family history, and they do it through videos and interviews, and it was quite interesting. And this type of thing would allow a trustee to go ahead and pay for that and encourage us to do that. But that brings into another question of vendors. And as a trustee, we have to do our due diligence on vendors. And so, okay, we're hiring somebody to come in and talk to beneficiaries about one of these topics, whether it's finances or mental health or family dynamics, and how do we vet the vendor and make sure that we're hiring someone who is going to provide solid guidance to the beneficiaries. So these are things that I'm starting to think about ahead of time, as how we actually implement these programs and this service.
It's actually a very interesting question. Let me ask all of you, how much knowledge is already in the DNA of trust companies to do all this? I think some of it to some degree is going to be new, no?
I know for smaller trust companies, well, I can't speak for more than Peak, but I think this is fewer and far between. So we don't do as much of this as some of Todd mentioned, the larger trust companies that have this in-house. With that said, this applies to all trusts. This is not just a trust with a minimum funding amount. So whereas, in the past, something like this may have been custom built for a very wealthy family, a large trust, beneficiaries of smaller trusts need education just as much. And so this would allow us to do that. But we're going to start looking at more, and this is what I think Todd and you were trying to do, is change this conversation. And so this will prompt us to start saying, okay, what is out there, and who are the vendors, who's available to give this these types of programs, and what does that look like?
I think you just made a really important point. So forgive me, I'm going to repeat something you said because I think it's really smart and important, and I wasn't thinking about it. Part of the purpose of the statute, and Todd, you may know more specifically than what I'm guessing, but if you have a family with $50 or $100 million or higher under management, you can run all these programs, and they probably already have, because a lot of these very large families have either family offices or a bevy of advisors and hire outside facilitators to run family meetings, and they do a lot of this. But how do you bring that down to families with lesser amounts of money? And it may be, can you do this for a $10 million trust? Can you do it for a $5 million trust? And apropos to Abby's comment, the smaller trusts may need it more, because if you have hundreds of millions of dollars, you're not worried about being able to buy a house, even one of many beneficiaries, or having food on the table. Whereas other beneficiaries of smaller trusts, if they don't get the financial awareness and education that this statute's talking about, that could be the difference between blowing it. And I think it was one of you had it in an example where, a kid gets an inheritance, they go out and buy a really expensive home, and we've all seen that frequently, and you can't have an expensive home without a good looking car or two or three in the driveway. And the next thing you know, the cars are worth, once you drive off the lot, 20% or something of what you paid for it. And the house is like the proverbial white elephant, you have to feed it. So they're taking money out of their investment portfolio and putting it into an asset that's creating an expense. And I've seen it many times, and it's always the house or the big vacation home, like in the Hamptons, and it tilts them to a point of no return financially. So I think, maybe part of the purpose of this was to make it more automatic so we don't have to spend a lot of time drafting. You opt into the statute, and now you can take these extra steps to help beneficiaries on even smaller trusts.
Yeah, I think that's right. And if the kind of beneficiary well-being program that might be provided by a trust might vary by scale depending on the size of the trust, right? So you could opt into the statute and have a beneficiary well-being trust that is, a $5 or $10 million trust. There you just might have, the trust officer having a Zoom or sitting at the kitchen table with the beneficiary, or there are sort of packages of sort of video, packets that you can buy that are training videos and different things like that you can view online, basically online education type things. And all of this comes under the umbrella of the trustee's fiduciary duties, right? So in terms of the duty of impartiality among beneficiaries, one branch is larger than another, whether this is viewed as a distribution or not, a lavish family retreat in Tahiti versus, everybody all lives together in the tri-state area and you have it at the airport, hotel or in somebody's backyard. All of that ultimately is, I think the guardrails are the trustee's fiduciary duties and the size of the trust and the duty of impartiality to protect and preserve the assets for future generations. You're not going to do the same kinds of things probably for a $100 million trust as you would for a $5 million trust and vice versa. And the same goes with whether this, we're going to talk about dancing along the lines of whether it's a distribution or just a trust administration expense. And, I am 100% confident based on my understanding of trust administration that there are ways to comply with the statute and provide these things without them being treated as distributions to the trust and still satisfy your duty to provide them and still achieve the desired benefit. But it's open. I think, Marty, you mentioned at the top, this is a self-driving kind of trust where you're not hardwiring in the document trying to anticipate all the things you're going to need to know is going to happen in the future, the size of the trust and the needs of the family. It's really just creating the, sort of the operating code to be able to deploy it and then leaving it up to trustee discretion and fiduciary duties to be able to implement it over a very, very long period of time.
Let me just comment. One of the many things listed was, for example, family meetings. What is a family meeting? And I don't want to belabor it, but on slide 26, here's just some of the thoughts about things that could happen at a family meeting. And I think Todd's examples of going from a lavish vacation, in a resort country or community to a backyard gathering with, a hot dog. It depends on the wealth level and the needs and interests of the beneficiaries. But on slide 26, I just list a whole bunch of the different things that could be involved in it. And the point I was trying to make is when you dig deeper, the statute mentions a lot of different things, but there's a lot of depth and breadth to each of the phrases that are used in the statute. So this is really just the tip of the iceberg. Abby, do you want to start just briefly on slide 27 if you have any comments?
Sure. Wealth management is the first purpose, and it's probably the easier to accomplish from a trustee's perspective because there are a larger number of known financial advisors and programs, and there are programs at even community colleges, and we're talking about what is a distribution, what is an expense. It's probably easier to get providers to educate on wealth management, and probably do it more by Zoom, and it's more it's just known, and that's easier to do. So that's an easy one. The family history again is which is the next slide, Marty. probably a little bit more challenging in terms of finding vendors. I mentioned we found one, and that seemed like a great idea, is to get videos and interviews, and they're a service provider, and that's what they do. So that would be a perfect example of how this would fit. And preserving the family legacy is such an important factor that often is overlooked in trusts. And what created the wealth, what created the family, and getting that to pass down the generations. So this is a way to encourage the preservation, which may not be on the trustee's mind, is how do we preserve the family legacy? And now it could be, especially if the beneficiaries are showing interest, or maybe if the beneficiaries aren't showing interest, maybe that's even more of a reason to encourage it and say, no, we are going to do something so that you understand where this wealth came from, what your ancestors had in mind, and what this is all about. So I think that's an incredibly helpful thing. The purpose to have connection among family members, that will be an interesting one, because family dynamics vary so much.
What a polite way to say it.
Yeah, and in some cases that's probably a very good thing. In other cases, well, there may be restraining orders, so we may not be able to do that. I mean, this is real life, right? This is what we see all the time. So certain family members may not be allowed to see other family members, and we get into all sorts of interesting legal issues. So again, as the trustee, I start to think, okay, how do we accomplish this? What are the things that we have to think about when we're trying to go for one of these goals, which are phenomenal for the family and for beneficiaries, and we just need to walk through to make sure we're not causing more harm than we are good.
Let me just make a comment. When they talk about some of the mental health and well-being provisions, I think just having, if there's even a Zoom family meeting with the advisors, just bringing up generically, because you may not know about addiction issues, mental health issues, chronic disease. There can be beneficiaries that have not disclosed to any of the advisors or the trustee some of the challenges. They could be embarrassed. And there's a lot of data about how as wealth gets greater, people are more embarrassed about some of the issues or challenges that they have. So just talking about these things at a family meeting that may have never happened may then help somebody feel comfortable to privately call the trustee or the attorney and say, I didn't want to say anything, but I got a kid that has such and such an issue. So really the benefits of this can be significant. And I know so many of us always shy away from the soft and fuzzy topics because what could be more exciting than digging into a technical GST issue? But this is really important stuff. And I hope that the statute really encourages more people to do it. I just had a few comments on some of the mental health and addiction issues because the statute seems to contemplate some of this as part of well-being. As wealth goes up, people feel more embarrassed and less comfortable sometimes acknowledging some of the issues or challenges they have. And there's complex connections between some of these challenges and sort of the emotional perspective that people of wealth take on it. Society often has less empathy for somebody who's wealthy because, if they have a problem, they can go out and hire somebody and fix it. Not always. So educating beneficiaries broadly about some of these issues can in fact help bring them to the fore so we can help them get the help they need. So this could be very, very powerful. Paying for the programs. Any comments, any of you, on fiduciary duties and the ability to pay for this?
Well, I think, Marty, it's going to depend upon what the instrument or the statute says. And it's pretty clear that under the Delaware statute, the trustee has the ability to pay for these things. That may raise in turn the question about what is the consequence of those payments, or what's the consequence of a beneficiary refusing the benefit. In other words, you have one of these all hands on meetings and some beneficiaries say, I don't want to go, or, it's going to cost me money to go because I'm going to have imputed income perhaps, or I have other things to do, or I could be out making money from my business. Those are kind of complicated things to think about, but I think they need to be considered by a fiduciary who says we're going to have a program and everybody is invited. Or I don't know, do you think, Todd, you could make it mandatory? In other words, the trustee says to the beneficiary, you have to come, and if you don't come, we're going to withhold distributions from you.
No, I don't think, I mean, unless the trust instrument says that, I think one has got to be separate from the other. And, you know, we did quite a bit of looking when drafting the statute, and I wrote an article in Trust and States magazine about the statute with some co-authors, and we all went off and did our research to try and see if there are any clear lines of when something is not a trust administration expense but becomes a distribution, you know, or vice versa. And I think that the deductibility, there's also maybe a not total clarity, but maybe it's a little bit more clear. You know, the stuff that we came up with in the article is, we said an expenditure is treated as an administrative expense if it's an ordinary and necessary expense of the management of the trust, and also that administrative expenses include expenditures necessary to effectively administer the trust. So to the extent the statute says the trustee shall provide these things, and that the beneficiaries have rights and interests as provided in the statute, which says they're entitled to these things, then providing these things seems to be necessary to effectively administer the trust, because it's the fiduciary's duty to the trustee's fiduciary duty to provide these programs. I don't think we were trying to move the needle at all in terms of saying this is just an expense or it's deductible or what have you. But there was surprisingly little that we found with respect to these types of meetings or educational components. You know, certainly if you pay the tuition for somebody to take a college course in finance, that sounds like a distribution for education and all of that. But I think the trustee would be attempting to avoid phantom D&I and taxable income, you know, of non-cash distributions. You know, they'd be going to great extent to prevent that from happening as an unintended consequence of providing these things. And so I think you craft the well-being program in a way that it looks and feels a lot more like an administrative expense than a distribution. And it, you know, because, you know, these things could be lavish and ridiculous and really look like a distribution, or they could be targeted and, you know, just provide what's necessary to accomplish the result. I wonder if you guys have any other insights into, because I mean, I've asked everybody, we've really given it a lot of thought, and we didn't try to tackle that with the statute. We just said, as you know, to the fullest extent provided by law, this is administrative expense, and then let the trust law figure it out. And that's kind of what it does.
Can we just hold that for a sec? Let's catch up to where that is in the slides.
Oh, I'm sorry.
No, it's okay. Let's just go through some of the other slides quickly so that we can get up to where that is. Slide 33 is really some comments that Todd made, that you can draft whatever you want in a trust agreement in Delaware. Just don't exculpate the trustee for willful misconduct. So you can craft whatever you want in your trust document. And the point of the statute is to highlight the concept of well-being, and it gives, as Todd said, an off-the-shelf approach for people that don't want to. Abby, do you want to just comment on some of the language here? And I broke it out into a couple of slides so it's bigger, but I don't think we need to get into much detail. We can move on to the interesting question that Todd raised a minute ago after this.
Could I
Sure.
interject one thing really quickly on that last point? We intentionally used the word governing instrument is what opts into this. And the term governing instrument is defined not only to include the original trust agreement, but a non-judicial settlement agreement, if you decant, any of those types of things. And I think the idea here is that if you have a trust now, and we see people coming to us after the trust's been created and it's really large, and they say, can we make this a silent trust? The trustee's about to start sending account statements out to our kids or whatever. You know, and again, this is an alternative to that type of an approach. But the idea here is that I think existing trusts can use the statute because of the term governing instrument that's used in the statute.
I wonder if that would work in other states like Alaska or Nevada without a statute. You know, can you decant and add these types of provisions?
Well, presumably you could, Marty. I mean, I don't know, you know, where the line between an administration expense and a benefit to the beneficiary is so clearly drawn. But we can get into that when you come to those slides.
Well, the other thing I was thinking of is the trustee can get compensation for providing these services, and some decanting statutes limit decanting if you enhance the compensation to the trustee. So you may get snagged on that.
Well, right, we, at least in Alaska, that can be overcome with getting judicial approval. So you might need to have a proceeding to do that, but in Alaska, we could do that with just going to court and getting approval of the decanting. So, Marty, did you want me to cover this slide real quick?
Yeah.
Okay. When we were preparing for this and thinking, okay, if you're not in Delaware, how, and we have with the other states, this is brand new, so have not yet caught on to this. I'm hoping that they will. I think Todd is too. But how do we go about drafting? What tools do we already have in our drafting box? And when I was a practicing lawyer, when I was drafting estate plans, I was an interactive legal subscriber. And so I went to the ILS language and said, well, what does ILS already have? Well, the language that ILS has, it is not exactly the same thing, but it's getting to the beneficiary, what is happening with the beneficiary over time, and they have guidance to trustee language. And so that's what this is, and basically trying to encourage the beneficiaries, the descendants, to be productive to the extent they can. There's obviously exceptions if they've got medical health issues, whatever, but that's what this language is. And so the language in this slide is language from Interactive Legal, guidance to trustee. That's optional language when drafting. And same thing there. So, oh, and then, so these are just other slides of possibilities for drafting, as to maybe you can expand your HEMS definitions, each one. You wouldn't want to go so far as to getting beyond the ascertainable standard. That's the tricky part, but you might be able to add some definitions in there as to what things mean. And that could give some more, at least grantor's intent and more flexibility to a trustee.
Would you do that by saying that the HEMS standard above shall include, to the extent it does not, violate the ascertainable standard required by the regulations?
Yeah,
that's how you would do it?
But I haven't done this, but that sounds like a good solution, Marty. I think that.
What about asset protection? Because if you exceed HEMS, don't you have under some state laws an issue that if you have, let's say a beneficiary trustee and they can exceed HEMS, that now you have estate and creditor issues?
I think you would want to make sure that the beneficiary trustee doesn't have this power and leave this to a disinterested trustee.
That seems
just
safer.
like you would, yeah, just like you would for just a broad standard, just a dispositive provision where it says for any purpose or in the trustee's sole discretion, you would only give that to a disinterested trustee.
Right. Letter of wishes. Any comments?
Well, I've used letter of wishes, Marty, for decades now. And everybody turns out to be a little bit different. As to what kind of discretion they want to grant the trustee and not grant the trustee. It's very, very individual, I've found, although people come out, they want the best for their descendants. They want them to live, fruitful lives. They don't want them to be, just do nothing for them. As Warren Buffett said, I want to leave my children enough that they can do anything they want, but not so much that they can do nothing, which maybe is the way a lot of us feel. And, you get into questions about if you have someone who wants to work for a charitable organization or do something that's not per se money making, do you make it up to them? Or do you feel that, they should have at least an encouragement to try to be as financially productive as their ancestors were from whom they're inheriting all this money? I found it very individual, but I like to discuss it with people, and everybody comes out a little bit different on that issue.
There's a detailed letter that I wrote, article I wrote that I gave you a cite for that may be helpful, because I think letters of instructions are really important. And they can be a letter to your kids about what you want for their lives. It could be letters to the trustees, and it may be different letters to different trustees, because trusts could be different for different beneficiaries. One could be a slat and have a spouse, and then another could be a dynasty trust. So informing people, I just find incredibly helpful. And I have found that whether it's binding or not binding, trustees, fiduciaries, trust protectors often read these letters and read them and reread them and reread them when they're trying to make decisions to get a feel for what it was that the testator or the trustor wanted. So I think it can be very helpful. Todd, you want to just explain quickly how Delaware has codified this concept?
Sure. Yeah, well, we had a bit of case law in Delaware on this, and we didn't want to alter what the existing common law was in Delaware regarding letters of wishes. From all the conversations that I've had, trustees love letters of wishes because they can see the settlor intent. It helps them with making their fiduciary decisions. Essentially, there's a lot of detail in our letter of wishes statute that might not be apparent to the observer if you just took a quick look at it. It has to be delivered to the trustee. Sort of, it has to reflect that there was an intent, because sometimes a letter could be, and in the case law that we have in Delaware, a letter could be circulated around the family, but not ever intended to go to the trustee. And all of a sudden it becomes that issue in a trust case and whether the trustee should follow it. And there has to essentially be sort of the intent that it be delivered to the trustee by the settlor or on behalf of the settlor, so that that they wanted the trustee to basically see and take into consideration the letter of wishes. It also could be delivered to the trustee at any time, at the time of the creation of the trust or thereafter, but it has to reflect the intent of the settlor at the time of the creation of the trust. And that's a big issue that you get into with these letter of wishes, if people suddenly start sort of making it up as they go along, 2 decades later or something like that. But the statute in Delaware does say that it has to either be what your intent was at the time or what your intent would have been if it was something that you hadn't considered at the time. So, for example, we talked about this, if you don't have any disabled descendants at the time you create the trust, and you never really gave that any thought at all when you created the trust, and 15 years later you have a special needs grandchild, what would you have intended at the time you created the trust for how that should be dealt with? And a letter of wishes could take that into account. Of course, you're going to get into some gray areas around there. And then there's provisions in there about, the trustees, doesn't have to necessarily disclose it to the beneficiaries and isn't liable for, relying on it or not relying on it and all that kind of stuff. But the real, sort of nuts and bolts of it are what I just described in terms of the trustee's use of the letter and what it can, sort of what the timing is of the intent and when it can be delivered.
Abby, you want to let me make just address the first one, where it talks about hiring, for example, people to provide services for the well-being of the trust beneficiaries. I just sort of summarized from a prior program I'd done a number of years ago, so these may not be current. I was just trying to illustrate the point that who you hire as a care manager or social worker, et cetera, to provide certain services for well-being, it's complicated. And I think that whoever's making these decisions is going to have to either hire a third-party consultant that's going to pick the providers or gear up on their own to get the knowledge. A lot of this stuff is much more complicated than just the simple terminology on the face of the statute suggests. Like, who do you hire? Who's a facilitator for a family meeting? So I think that, and I think this is a good thing from the statute. It's kind of encouraging all of us to dig into this stuff and learn more about it so we can really do the job right. Jonathan, you have some income tax questions about all this.
Yeah, I mean, when I first read about this, I wondered whether or not the beneficiary, let's say you're paying the beneficiary to come to a meeting, does the beneficiary have income? Or as Todd indicated, if you're paying for the beneficiary to get financial advice on how to better manage his or her wealth. And of course, a lot of people do not manage their wealth well. And so, you know, you give them education for it, you hire someone to do it, you pay for them to go to a course on it. It seems to me that that probably is a distribution from the trust to the beneficiary and may consist of distributable net income, which means it's going to be includable in the gross income of the beneficiary. Now, one of the things is, even if you're doing this for educational purposes, unlike Section 2503E, which now has an exception where you pay for someone to have education, which is provided directly by the educational institution, or you provide for someone's healthcare directly from the healthcare provider, it is not a gift. But that's kind of irrelevant here. You can say, well, we ought to take that into account. But I think if you're paying for a beneficiary to get special training, to learn things, I think in almost all circumstances, that's going to wind up being income to the beneficiary. Now, maybe you can argue that if you've invited everyone to a meeting and all the beneficiaries are asked to come, that's just part of the administration of the trust. I think you can make a very strong argument in that case. But as you define it per beneficiary, this beneficiary wants this or needs that, which is one of the things I think the Delaware statute and what I've done in my instruments trying to do is basically put it for that particular beneficiary's needs. I think there's a very good chance that it's going to be, you know, income. Now, if it's something, you know, Todd gave an example of, you wind up having a child at age 16 who winds up to have developmentally challenged issues, and you wind up providing special care for that person. I think, you know, again, you're probably going to have imputed income. And I don't know that it matters whether or not the beneficiary is a minor, except in some circumstances, and the regulations provide for this. If someone else is benefiting from it, then you may wind up having the parent actually have to pick up that income. So, for example, if the parent is obliged to provide for certain medical care, maybe it's the psychiatrist or whatever, which under state law, the parent would have to do, but the trustee provides it. The parent may be the one who picks up that income. That certainly could happen in some cases. And it may be that, you know, all of a sudden the beneficiary is told you have $25,000 or $50,000, pick a number of imputed income, and the beneficiary says, I got to pay tax on this. And the answer is yes, you do. Good news is the trustee gets to deduct that from its taxable income. But yeah, but I got to pay the tax, so you've got to give me more money. So the trustee says, okay, you know, you've had $25,000 of imputed income, so we're going to give you, you know, $12,000 to pay that tax. But that payment itself is going to be taxable income. So you have that very gnarly situation of tax on tax. And I think that that really needs to be thought through as you administer one of these trusts.
Do you Todd, any further thoughts on it? Did the committee dig in any deeper on that?
Yeah, you know, I think that's in the wood in terms of, you know, if you opt into the statute and there are beneficiary well-being programs being provided by the fiduciary that constitute, you know, are basically distributions. You might true up with cash if there's DNI, and that's the tax position that the trustee is the one that's going to be filing the, you know, is responsible for preparing the tax return delivering the K-1. So the trustee's going to have to make the determination of whether it's a distribution, I guess, or not, and then would also be responsible for the distribution decisions about whether to distribute cash to true it up. But I also, as I was mentioning before, think that there, if the beneficiary doesn't want phantom income and DNI, the trustee shouldn't be providing programs that would trigger that if there are alternatives that are more like administrative expenses, like just having a phone call with them, as opposed to, something that's, instead of giving them a college course or, anything in between.
Can I make a suggestion?
Yeah.
I bet Abby and Jonathan will like this, but I'm not sure you will. Maybe what you should do is have one of your trusts pay for certain types of expenses and seek a private letter ruling as to which are taxable, which can be deducted by the trust. Somebody in
Marty,
Delaware should do that, because maybe we'd have.
well, Marty, that's a good thought. I mean, what is, Todd hinted at this, what is an administration expense as opposed to a distribution for the benefit of the beneficiary? I mean, arguably, everything that the trust does benefits the beneficiary, but, hiring someone to manage the assets of the trust, getting advice as to how the trustee should invest, when it should make distributions, all of that is going to be an administrative expense, even though the beneficiary, at least indirectly, if not directly, benefits from that. I mean, I must say, I've never really, and Todd, I commend you for the statute, because I had never really thought about that. But certainly if you say to the beneficiaries, hey, we're taking everybody to Tahiti to have a big family meeting, I think, you're going to pay for everything, your airfare, you can fly first class, or, we'll send, get a private jet. I think there's a good chance you're going to have some imputed income. But of course, for most people, that's not going to amount to that much. But for, the kind of people that Marty and Todd are, that could be a pretty big expense.
So,
and if you have beneficiaries who aren't included in that, they're going to sue the trustee for breach of fiduciary duties, for, basically wasting trust assets and all that stuff. So, yeah, I mean, like I said, I guess there could be anything from a phone call to a trip to Tahiti and everything in between, right? So who knows?
And if I can interject, I mean, all of these are good points, but remember, the idea is the trustee has discretion, and this is what we would look at, right? These are some of the factors that a trustee would consider and what to do. One, what does the trust say, right? Does the trust agreement go beyond the statute or invoke the statute? Who are the beneficiaries? Are they 5-year-olds? Are they 50-year-olds? Are they somewhere in between? How many do we have? How many lines do we have? Duty of impartiality, all these duties. And then we would also look at how much cash is in the trust, what's the cash flow, what can we afford, what are the potential income tax consequences. And it may be a situation where the trustee talks to the beneficiaries and says, look, we can do a Tahiti conference. There may be income tax. Beneficiaries may say, we don't care, we're good with that, we want to go to Tahiti anyway. Or maybe they don't want that, and so, okay, instead we're going to do Zoom meetings, and it's going to be less expensive, and we're going to accomplish these things. So all of these are really important factors. They're factors. And so when the trustee is exercising discretion, it's one of the things the trustee needs to think through. But by no means is it a reason to not do something. It's just do it differently if need be, in a way that minimizes that exposure and that risk. I like the private letter ruling idea. I think that's a good idea, but I'm not volunteering. Just
Didn't Todd volunteer? Didn't he raise his hand? Did you guys see him raise his hand? I think we've really covered a lot of these risks and issues, and I think a lot of develop over time. I'm going to ask each of you to make a concluding statement. I'll just make a quick one. I think it's wonderful what you guys did in Delaware, Todd. I think, putting an emphasis on the human aspects of this is really what every client wants. It's not how many chips you get to the next generation, it's what kind of human beings they turn out to be. And to the extent this just puts it on everybody's radar in a more pronounced way, I think it's wonderful. Certainly there's kinks we have to work out with it, but I think overall, we can only benefit the beneficiaries by trying to address, the human aspects of who and what they are. So I think it's wonderful. Todd, why don't you give any summaries or final comments that you want to make?
No, I've said a lot already. I think that raising the awareness of these issues and hopefully moving the needle a little bit in terms of the conversations that planners are having with their clients and bringing more into the client's awareness to think about these types of issues and what exactly it is that they're doing when they're creating these trusts and what the future is going to look like for their beneficiaries is all good stuff. And I hope there's I hope other states adopt statutes that are like this. Maybe they can make them better. And I think that would take this in the right direction for beneficiaries, grantors, and the fiduciaries.
Abby, any final words or summations?
Thanks, Marty. Todd, thank you for bringing this forward. I think this is a leap forward for beneficiaries, and I'm excited to see how it plays out and see what the experiences are. And I'm sure there's some surprises along the way, but it's a great change and a necessary change in the conversation.
And Jonathan?
Marty, I think you guys have said it all. I mean, this is something that really needs to be attended to when you're dealing with a family. As I said, you start with certain things about how much wealth do you want your descendants to have? How should that wealth be managed for their best interests? Do you want it unlimited? Are you going to provide them with so much that you take away their incentive to accomplish great things in life? And those are difficult issues, especially for people who are as wealthy as Todd and Marty are. I mean, they always have these difficult things. Many families that I've had the privilege of representing have actually been ruined by too much wealth. In fact, I think you could write a pretty good essay that great wealth is worse than having very little wealth at all. I mean, I regard the #1 family in America, which I've had the privilege of representing for a long time, has been the Rockefeller families. And there is no entitlement in the Rockefeller family to anything. It's all discretionary, and counseling about that begins at age 7, which I've told a lot of my clients about, and they always have independent people who make those decisions. And I think that has served the family now in the 6th generation down from the man who made all the money, John D. Rockefeller Sr., has served the family extremely well.
Thank you, everyone, for joining. Thank you for listening to the program, to everyone listening, and good luck. It's interesting times, and hopefully we'll keep finding ways to do better what we do. Thank you, everyone.